All right, Deputy Laura, does he need a mask? That cough doesn't sound well. Well, Bashan, today is Thursday. That's a good thing. It's Friday's Eve. Yes, it is. And I took my flu shot yesterday.
Okay.
Yes, but I'm not doing that thing where I take the flu shot and every other shot together. I just can't do that. And the one time I did it, I went to the doctor and they said, why did you take all these at one time? I'm like, they said you could. So never again.
My arm is sore.
From the shingles?
Yeah, not shingles.
I mean, well, from the shingle shot.
Yes, my arm is so sore. I went home and I just like crashed out.
That's what happened to me when I did the COVID shot and the flu shot all at once. Never again. All right, everyone. I am going to call the docket. And if you're here, let me know that you are here. In custody, we have Ernest Morales, Roberto Gonzalez, thank you, Devin Stryjek, Mariana Barnes, and Deputy Laura, since it's raining outside, I'm going to give everybody till 10:30. Uriah Huffman is in custody. Jimmy Barrientos. Christopher Lemaire has been reset. Megan Wilhite, Sarah Espinoza, Christopher Armstrong, Christopher Robles in custody. Christopher Chandler. In custody is Kavonda Jackson, Fabian Cardenas. In custody, we have Jessica Johnson, Christian Smith, Keenan Brown, Joshua Mejia, Tyrone Eds, we're going to see if I'm pronouncing that last name correctly. We were always taught in school when two vowels go walking, the first one does the talking. So we're going to see if that's true. Gabriel Bernal, Ernest Morales, Christopher Morrison, sure. John Schulte. All right, thank you. And then Terrence Smith, I believe that's at 11. Rolando Valadez. Oscar Martinez, custody. Raul Peral.
He should be alive.
All right, thank you. Frank Torres. Was that reset yesterday? I'm gonna have to see about that. Roberto Barrientos. Oh, sorry, Robert Barrientos. Steve Terrazas. Thank you. All right, everyone. So as you all know, I try to keep the courtroom as least congested as possible. I do it for health reasons, but I'm also from here on out doing it for security reasons as well. I know that everybody is aware of, how could I best describe it, the melee, the brawl that happened in another courtroom. And that was because, well, I don't know what it was because, but we're going to eliminate that in this court. So the only people who will be allowed in this courtroom are people who are actually on the docket and their attorneys. So if you have family members, friends, people who are supporting you, they're going to have to wait outside. If they are witnesses, they will be called in when it's time for them to testify and not before, because I want to make sure that everyone is secure and safe, because I think this should be a safe place. And I don't want the deputies to have to deal with 40 people, because if you can imagine, the deputies in this courtroom are fantastic, but Today we have 3 of them, but usually there is only 2 of them. So they're in charge of my security, the attorney's security, the people who are accused security, defendant security, everybody. They're in charge of the whole courtroom, and that's a lot for them to do. So from here on out, those will be the only people who are coming and allowed in the courtroom. So if you have people who are here to support you and they're not here to testify, you need to let them know that they are not going to be allowed inside the courtroom. Of course, the courtroom has to be open to the public. So that's why we live stream. All right, so files over here are criminal trial division. Over here is family violence. Court reporter, don't touch her things. Don't lean on her things. It's very expensive. Probation officer is back there. If you have someone who is on probation, do not approach the court if you have not conferred with the probation officer. And please keep this area clear for the line of sight for the deputies. So it's Friday's Eve. Let's have a great day. Everyone, please confer. December 4th. Which page is that on? Okay, thank you. And I already wrote that in the file, correct? Michael? Yes.
Hey,
Hello,
Judge,
yes.
I'm waiting for Jason Durham to get here, and I'm waiting for my client. I'm just gonna run to another court. And I'll be right
Sure, no
back.
problem.
I appreciate it.
You're welcome. So today it'll be, Thursdays are usually anything that we have stragglers. And by stragglers, I mean, maybe the attorney came in and wanted something put on the docket. So we'll have, and we also have compliance hearings. And compliance hearings are usually probation cases where maybe there's a young person who's 18 or somebody who's 20. They have an issue on probation. Maybe a young person hasn't been reporting. And so I bring them in for a compliance hearing instead of just immediately filing a motion to revoke to figure out what's going on with them. Because I don't take joy in sending people to prison. And if there's an issue that's going on with them or an issue they brought up with probation, I want to see what the issue is. Sometimes it's an issue we can solve. Like maybe the person didn't report because they said they would get fired from their job if they missed another day. And on those type of things, we can work things out. And sometimes it will be, hey, let them report by Zoom on their lunch break. Can we do that to figure things out? And then some of it is sentencing. So that's where people enter pleas. And now the probation officer has done a report, and it's called a PSI, which is a pre-sentence investigation report. And it'll list if the person has criminal history. We will have a recitation of what happened in the case that they're here for today. It will maybe have a TAP evaluation, and the TAP evaluation is just to see if they have a drug or alcohol problem. So it will ask you things. What's the first time you used this drug? If you've ever used this drug. And then sometimes it'll have statements in there from the complainant, the person who's accusing the person. And they'll say, oh, I want them to have probation, or I don't want them to have probation. Usually in the domestic violence cases, I would say probably 80% of the time, the complainant will say, give them probation. Or sometimes we have cases where actually the complainant is a relative, and they'll say, give them probation. And they'll say things like, the person has mental health issues, or the person has a drug and alcohol problem. That's what they really need help with. So that's happening on today, the sentencing. And sometimes we have stragglers that are motions to revoke. So once the motion to revoke has been filed, what ends up happening is probation will send a form to the district attorney. And when I say district attorney, not so much Joe Gonzalez, but the attorneys for the court. And it will say in there, okay, this person didn't report, this person maybe picked up a new case, this person is testing positive for drugs. It'll have all that in there. And then the prosecutor will look at it and sign off on it. And then once they sign off on it, then it'll come to me and I'll review it. And then I can either sign off on it. And if I sign off on it, that person is going to be arrested and they have to make fine. Or sometimes I can do a summons. For example, if the only thing in the motion to revoke is maybe someone's testing positive for marijuana, or somebody hasn't done their community service hours, sometimes I'll do a summons. And a summons is, you don't have to pay a bond. You just have to show up to court to answer for this. And then sometimes it may be somebody owes restitution. That's the only thing they haven't paid, the restitution. So I don't want them to make bond and pay for that, because that money should go to what they owe somebody. So that's usually sometimes what I will do a summons. And then sometimes the state and the probation officer will come to me and say, hey, can we do this as a summons? Because this is, we're really trying to get them in. And that happens sometimes with people who have mental health issues. So once they, let's say I do sign, they go to jail, either they make bond or they don't make bond. Sometimes an attorney will come in. Hi. 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 Yeah.
Just a couple things.
Sure.
Saw the notes, that the not allowing anybody else in Portland.
Mhm.
There's this one case, majorly is a Ryan Huffman case.
Mhm.
The victim is here.
Okay.
And you really understand if you see him, like you read
Mhm.
sick. I mean, it's pretty dramatic thing.
Okay.
So he may, I'm asking if Tim Bob to be inside.
Oh, no, they can come in if there's a sentence, but how many is it?
This is two.
All right.
Mom and-
And you'll have to let the deputies know who they are.
Okay, and then there's one other one where it's the victim's mother on the, it's a sentencing that's straight sentencing of 2 years.
All right, so-
Bonds.
So we'll only allow them in when the case is actually being called.
Okay.
All right, sure. Yes, so we try to make sentencing days and motions to revoke on a Thursday because we have such big dockets. And the other days are usually cases where people have not entered a plea into. And sometimes it's discovery. And sometimes we're waiting forever for discovery. There's one case, I think we've been waiting for discovery since 2022. And so I've told them, we can no longer wait. At some point, the case must be tried. But so those are on those days. And then on Tuesdays, we actually have jury selection. And then we do jury selection usually in the afternoon.
This is him in real life, just like this.
Of course, if it's a case where people want 2 hours for voir dire, then
They were fighting.
we'll end up probably starting
So.
in the morning, because I don't like for people to be here late at night for jury selection. So,
You're doing
yes,
that right now. It's in the bottom,
so
right?
that's what happens.
OJ, Last Supper. The best one, I think. is-
Well, Wednesday,
They
we
put it
don't
in
have a
way.
docket because usually it's for all day testimony in a jury trial.
Oh, he's seen it.
So
Absolutely.
usually we do half days
I love it.
for juries.
Actually, I was telling you
But
yesterday, we ran into each other.
If I
Saturday,
did half day
so
every week,
you know how these
the
things-
trial would last very
that
long.
interviews and you
And when I'm
go
thinking
to
about
the tower.
jurors,
Earlier on this.
yes, this is supposed to be what you give back to your country.
Walking to lunch.
But then you're not supposed to make it so inconvenient for jurors where they're here forever. We did have a case one time where it went over a month, and that's unheard of, but there were a lot of videos. And I want both sides to be able to present whatever evidence they want to present. Of course, the defense doesn't have to present any evidence at all, but sometimes they want to, and I don't want people to feel as though they're rushed. And I don't want the jury to feel as if they're rushed when they're deliberating. So I try to make it as convenient as possible for everybody. So. I remember when I was practicing, it was like, do it now.
Yeah, well, yeah, that's true, that's true.
They just said.
You know, Judge,
Huh?
how are you this morning?
Oh, I'm doing great. It's Friday's Eve. How can you not be doing great on a Friday's Eve?
Well, Judge, I'll tell you, new wife, new kid. Now, I only have 2 kids. anymore.
Okay, see, he's always doing these shows.
I figured, forget the other 3. I want 2 new kids. We bought a house up in, I think it's maybe kind of the Northeast. We're new homeowners, Judge. But you know, it's weird. We had a priest come by to bless the house.
Okay, see, here he
It's
goes.
true. And then he couldn't get out of the room. And it was
What?
all of the, Judge, hundreds of flies. And I wanted to call him, but the phone wasn't working. And it's just, 2 bad homes in a row.
Oh, that is so
I
hilarious.
may have watched that last night.
Oh, that's right.
Well, Bashan, let me just tell everybody what happened to me. All right, so I was asked to babysit a dog, right? So I'm babysitting this dog and it turns in, now I'm no longer babysitting the dog. I actually own the dog. So every day we go for our walk and we would go for our walk. He kept running into this lady's yard and she says, hey, I'm going to call somebody on you. And next thing I know, they're coming, they're trying to take my dog. And you know what ends up happening? So I go to sleep. And when I go to sleep, I wake up, right? And it's because there was this tornado that blew through. And then when I walk outside my house, I see underneath the house, there's some lady, the house landed on her and she had on red shoes. And all these people start saying, come out wherever you are. And I was just like, what? And then this lady comes down in a pink dress. And this other weird lady comes in and says, those are my sister's shoes. Yes. And then this lady in the pink dress, guess what she does? She puts the shoes on my feet and she tells me these shoes must be very important because this lady wants them. And you know what I told her? I said, but legally, isn't she entitled to the shoes? Because she says this is her sister. I'm not in her sister's will.
Is that right?
That's right. Yeah,
We're living very interesting weeks this
We
week. You
are.
and I really.
and I'm telling you, it seemed like I was there forever, but I made it back here. You know how I made it back here?
Maybe something to do with the shoes, but I'm just have to guess.
I clicked my heels 3 times and I thought of home. And it took me back at the house, but then it said, no, you're supposed to be in the hotel. So I had to drive.
Yeah. It doesn't happen.
Hi. Zach, do y'all want to look at this and see
Absolutely, Judge.
what his bond conditions are? So, and then sometimes you have bondsmen. They will get off somebody's bond because maybe they're not reporting. And that is separate contract. And people sometimes think I have something to do with the contract. For example, sometimes somebody who's accused and on bond, they'll come in and say, I paid the bondsman. I don't know why they're trying to get off my bond. And I have to tell them that's a contract between you and the bondsman. I don't read that contract and say whether the bondsman is being good at the contract or not. That's for a completely separate court and completely separate thing. So sometimes a bondsman will get off the bond. Maybe they say that person didn't report. And then once they get off the bond, then that person will have a warrant out for their arrest. And then what that is a reinstatement request from the bondsman. So sometimes what will end up happening is the person will call the bondsman. and say, I promise I'll show up, or either sometimes they haven't paid and they will say, well, let's do an installment agreement. And somebody come in and make the first payment and then the bondsman will get back on the bond. But before I reinstate the bond, I always want to know, one, what's the reason that they got off the bond? And two, if there are some issues with regards to the complainant's safety or something else that should be put in there as conditions. And so I don't have that information because those are unindicted cases. So I always will hand it to the prosecutor. And if they have an issue with reinstating the bond, then we'll set it for a hearing. And the court coordinator, I have them put that on the docket ASAP. Like if they want to put it on the docket this afternoon, we'll have it on the docket this afternoon because I don't want somebody staying at the jail if they're not supposed to be at the jail. So that's what happens. And I will tell you pretty much during the holidays, Christmas, everything around the courthouse slows down. Because one, we don't have any jurors at a certain point. So what can you do? And in this court, for the holidays, Thanksgiving, Christmas, I always like to give staff and everybody a break to go spend with their family because some people are out doing a lot of shopping. Then you have some people on my staff are parents. Some of them are single parents and they have to pick up food from the grocery store, prepare the dinner, do all of this, make sure their child knows that Santa Claus exists, then go to church and do all of that. And so I never want to have that interfere with their ability to do that. So usually I give them that time off, whether the court's supposed to be closed or not, so they'll have that. Yeah. Yes, usually, well, no, usually for Christmas, I will give them Christmas through January 2nd. And the reason why I do that is because their children are off from school and no babysitter, no daycare, or if they have, that's a lot of money to pay for daycare, to pay for a babysitter. And government jobs don't pay, regardless of what people think, government jobs do not pay a lot. So what we do here.
Yeah. I mean, it's 3 days. So that's already essentially trial on. That's true. Yeah, that's right. How do you know about this one? Oh, okay, got it. No, you're definitely right. It's like the operation. Hey, Judge. I promise to this.
All right, thank you.
Yes, ma'am, absolutely,
All right, thank you.
absolutely.
And I'm assuming the bond conditions already have a no contact order or no?
Correct.
All right. All right, so this is what the affidavit to reinstate surety or bond looks like.
Yeah, we had bond. For obviously 10 years.
And Jason, if you want to look at this. So. See, and the problem on that is the blurry photos, so.
That's like a layer.
I think that's
It's two
I think that's
Mhm.
tampering right there, so. Yeah.
And so I'm trying to see, because they're saying, they're asking the vendor to replace the camera, and they're asking the defendant to contact the vendor to have the camera replaced.
Yeah.
So I'm sending it back. Has the camera been replaced? If not, we're gonna have to have a hearing. Yeah.
Oh, Judge, on the,
Yes. Mhm.
The mother wants to have a defense at the letters,
Mhm.
sent by our office, and she wants that to be read before fencing, and for it's supposed to be after.
Yes.
She's very honest, she's not happy with the food, she wasn't happy with the news. She wanted to talk to you, I told her, that's up to the court, I go, let the judge know. I go, she's going to give you the letter.
You took kind of like an-
All right. And which case is that?
It's on the first page, it's a PSI, it's the John Young.
Okay, well, the defendant hasn't arrived yet.
Okay, so okay, so then it's on my.
Mhm.
Okay,
Yes.
so.
And so is this a cap of something or?
It's it's a reduced to kidnapping, 2 years to.
Oh, okay. Well,
I mean, if she
I
doesn't
will,
show up,
yes, yeah. But I will read the letter then, since it's just to do,
well,
yeah,
then
I'll read it beforehand.
I'll go get it from her. And
Okay.
is that okay?
Well, after John Young says it's okay.
Okay.
Sure.
Well, yes, this is the only one.
Y'all can go one at a time if you want it before the.
There or not there.
There's. I had my morsels. You know, with my time, and, you know, people won't answer.
All right, and if you want to come around, I'll show you what a PSI looks like.
Well, that's this.
So let me find one here.
Very sensitive.
All right,
Oh, that's
so
not-
this is a PSI,
Okay.
and
Yes.
what it does is you can see here, it'll tell you who the prosecutor was. And so this is just the person who entered the sentence, not necessarily the person who's on the case.
Okay.
And it'll tell you who the sentencing judge is, the court, who the attorney is. And then it give you the cause number. And it gives you information and whether or not they have AKAs. Sometimes AKA is not necessarily somebody who's saying, oh, my name is, I'm sorry, just one second. Hello? Another spam call. All right. So sometimes, you know how when you watch television shows and somebody's name is Big Bear or whatever, sometimes the AKA is merely that, say, for example, if somebody's name is John Doe, and on all the paperwork, it says John Doe, but it comes out that it's John Doe the third, they'll put an AKA as John Doe the third, even though that's his real name. And then it'll give you their age and everything and where they were born. They give you all of this. And a lot of this they get from going into the system. And DPS has a SID number and Bear County has their own SID number. And you get your FBI number as well. And then it'll tell you here whether they acknowledge guilt or minimize guilt or didn't discuss. When I was a defense attorney, I would always tell my clients, it's best that you not discuss. And it would depend on what type of case it was. Some cases you're saying, hey, you need to really accept responsibility. But some cases, if there are going to be issues of civil liability, when I've already had them to plead no contest, because maybe there's civil suit going on, I would tell them to say, on the advice of counsel, I'm not going to discuss, what happened.
Yeah.
That's better than having they minimize their guilt. And then here, when it says custodial information, that gives you a list of all the times they were in custody, or what cases they went to Bear County Jail for, what cases they went to prison or jail for, out of state, out of county, that's all here. And it'll start with your juvenile history. And here, this is the juvenile history, and it'll go all the way down to the other history. And then it'll tell you what happens in each case. So you'll see here what happened. And then it'll even tell you if somebody's been in federal custody or not.
When it's continued, it means like it's ongoing.
No, this just means that it's continued from this page.
Oh,
Yeah, no problem. All right, and then you have this,
Yeah, yeah.
and it'll tell you how many felonies they've had, how many community supervision. And community supervision just means probation. And there are different types. Community supervision by itself is you got a conviction, but you're on probation. Deferred adjudication is a form of community supervision. It's just one with the conviction. And then it'll tell you the number of misdemeanors and how many convictions for misdemeanors. And then it'll tell you this. And I think this is wrong because previous incarcerations, they're like jail now. And it's like, he has been in jail before, so that's wrong. But it'll tell you if they've ever been to safety or whatever. And safety is a drug rehab center that's at the prison. All right. And then they're saying you have criminal histories in Bear County and Comal County. And then they'll tell you the first age of conviction, whether or not there's any gang affiliation. A lot of times I'll ask people about their tattoos because one, I'm interested in their tattoos. And usually when you have people talk about things that they're passionate about, they open up and it can help me make decisions on what conditions they need. But sometimes tattoos are associated with gangs.
Yeah.
And so it'll let you know if there's a victim associated with, yes, all right. And then who is the victim, right? And then they'll give you the name. Usually with this part, I always want to know what the restitution is. Sometimes people don't send in receipts. You just can't say, oh, I'm owed $4,000. People like, where's the receipt for that? So you're not allowed to do that. You have to give receipts. And then this is where they try to contact the complainant, but they're saying they have been unsuccessful in contacting them, which that person should be easy to contact, but they're saying they having problems contacting them. So this one, they're saying it's $5,700. Now, once that's entered, people can object to it and say they want a hearing on it. And then I'll make a decision on whether it should really be that. And they, yes. When is he set with Judge Angelini?
Just a random.
All right, can you call him and see?
So I'm looking and I look.
So then
I was looking at the audience. No
they
one-
say, blending the paint, the door, this is how much all of this costs. And then they'll say psychological evaluation, any mental health issues, they'll list it there. Are they taking medication?
So.
Then they'll tell you how long they've been in school, all of that. So highest grade completed here, that's, yeah. And then it'll tell you whether or not they got their GED. Yeah. And they'll ask you what's the principal language? And, they're employed. Then they put in, whether or not they have military service. And then they'll give you a narrative. And a narrative will just be from the defendant's perspective. And they'll just ask, where were you born? Tell us about yourself. That's what that is. And the official version to make sure that the PSI reports are prepared quicker than they usually were. Some of the judges decided, look, you don't need to put the official version in, which is the police reports, because we already have that. We just read it in the stipulations. So usually they'll put the narrative in, because when they put the official version in, they have to go in and get those police reports, read them, and then put it in there. And so this just makes it easier. And so that's it.
You're kidding.
And see,
okay.
yeah. So yeah, that's what this is all about.
And each person gets one.
Yes, well, it depends. For example, sometimes the state is silent. And when they're silent, I just really need to see what their criminal history is. So I asked them to run an NCI, TCIC, so I can see what the criminal history is. And then maybe I can make my decision on that and they can bring in witnesses. Because if I did not, what would end up happening is that would be another long case waiting for all of this information to come to me. Yeah. Sure, you're welcome. A number, were you able to reach him? Okay. Okay. Mariana Barnes. Oh, she's in traffic. Okay, thank you. Rolando Valdez. Rolando Valadez. Raul Paral. Raul Paral. Robert Barrientos. Okay, all right, thank you. All right. And that's the other thing that attorneys, oh, your client called
Yes, she's called me
Yes.
too,
and she called the clerks in the back and said that she's stuck in traffic, but she's on her way.
and she called me saying she couldn't come today because of the rain. And I said, you know, I'm stuck in traffic too. You can come. Well, my windshield's broken and I can't drive in the rain. I says, find another ride.
Yeah, via,
Hopefully it was after my conversation that she talked to you.
okay,
Hey, Judge, Mr. Young and I spoke, and I spoke about the victim of that letter. He said he doesn't oppose.
all right, so if you'll give me the letter, I'll read it.
After the sentence.
Oh, wait, I thought you said you didn't oppose it if she read it before. Since it's a straight sentence. Well, I guess, you know what, since she might not show up, it might be open, so it.
Oh,
You're
there we
correct.
go.
So it may be open at this point.
Okay,
We'll see.
all right, thank you.
Yeah, okay.
If you don't mind, I'm gonna go to another court. and
Sure,
I'll
no
check
problem.
back with you.
All right, thank you. Hello. And then what I'll do, while he's doing that, I'll see if there is, who knows, maybe there'll be another room available for him or something. Oh, Okay, all right, we'll find out. So if you want to give Mr. Owens his reset form, you can. Ah, okay.
Yeah, a little bit not really. Every woman has a. That's what that. Well, I had two, so that's why I believe in every woman that. Sorry.
Well, not that it's one, so it's so that. What if the one of these?
Right. Really against God. God. Like, I got it.
Yeah, those, like, apparently those were like concepts and laws and. Yeah. Still.
The thing is, I didn't even know about it. Like, literally the ones that are. I felt
I don't know that they'll take one because it's.
Yeah.
Maybe, intensive outreach. I'm sure they have them done.
I'm so next.
Yes. Mhm. Mhm. Yes. Yes. Sure. Yes.
Small meeting in your neck of the woods.
What? There was?
Where's your case out?
What we had, wait. See, I told you all about the house and nobody believed me. Well, I hope nobody got hurt.
Yes, nearby.
Oh my gosh. Well, tell mom I'm okay. I had no idea. I guess I was really sleeping through the tornado.
There was a tornado where?
Downtown.
Downtown, small tornado was caught on
Huh.
camera this morning.
What time? Because when I was driving in, I saw clouds that looked really close. But it was like that.
Did you find it?
Yeah, I found it. I was so, wow. No wonder I slept so well, but you know, I used the blackout curtains, so I don't know what's going on.
I agree with that.
That's wild.
Yes. Are there any good movies coming out this weekend? I don't think so. I'm like.
Motion for the option. I'm just about to. I got on my hands.
We're one of the three sitting at this next time.
Yeah. Okay.
Yeah.
I can have like, calls, yeah, I can have her reach out and just see what she does.
That is so. That is, I thought it was fingers. Yeah.
It's a temporary order.
Oh, man.
December.
It's like it's December.
No, she's. I think she had true.
Yeah.
One of the comes to CSI, like, there's a lot of things.
Oh, they're real. Especially, I can. Some of my own that are all.
Yeah, we'll check out. Yeah, that'd be fine. Yeah, I appreciate it.
Yeah.
So, okay, well, yeah, it's like the next day. Then I don't care. Start to crack it down.
We even have to. Let's. I think about my client Saturday. Sorry.
No, you're good.
There's a lot of stuff that's often.
Yeah. No, I understand completely.
And then a lot of times, court is just waiting for attorneys to confer with their clients.
There's like.
Negotiate with the state.
And there are a bunch of grand jury packets. Yeah, and it's like, one of them is often say like.
Yes, whenever they're ready. Mhm. So right now they're conferring, and a lot of times, because attorneys are solo practitioners, they have to be in a lot of courts. And so usually as a defense attorney, you try to time your schedule where, oh, I'll go to this court first, and that should take like 10 minutes, then I go to that one, and you go on and on. But sometimes a monkey wrench is thrown in the plan because maybe your client doesn't show up on time, or maybe the judge is late, and then that just throws everything, out of order. Yes.
I don't think it's gonna matter. See, that's the discovery. Oh, I didn't see that. Good job, that or change. Oh, yeah, Joe drafted two. Yes. It was juicy. Yeah, have a good That's. Yeah. I think he's kind of somewhere. I don't know. No, the thing is, since he generally gets bad heart. Lifelong use cocaine, other was narcotic. Severely diabetic, even a 15%, so you can change skin with diet. So I walked through there, then he went outside. Yeah, but outside's more fun. So conscious of fun part. I'm afraid it's worse than somebody else. No, that's wrong, right? There's all this laugh. Well, let's see.
Well, there's.
So the offer was like.
I'll be right back.
437. That's either about. Blatant packet, right around, all about it. That's not some. Photos too. Yes.
Yeah.
But I'm not gonna say now. Yeah. Dark, so there's somebody. Yeah. I don't know, I'm probably gonna tap.
We'll see how it looks when I.
No, it's got to be activated.
So. I have a shirt in the office that's just from this dry everywhere except for right here. That was kind of cold, I don't know, yeah.
I never strike, we don't see his file in the box, just want to make sure he made it to the docket. Okay. I did. What's, yeah, I talked to him, what's the file number? 754, thank you. All right.
I'm gonna need to approach one.
Yeah, they don't have their file, but they're ready to go. Like, it's just less than a gram. They'll need the file. Yeah. Yep, we're ready to go. Thanks.
Yes.
What's going on?
Not much. Less exciting this week. Last week.
All right.
All right, everyone, please be seated.
Yes.
All right. Yes. Hello. Thank you. All right, who's here on Christopher Chandler? All right, are you all ready to proceed?
He wants to. My client talked to him this morning, do like see if he could get a reset to hire an attorney. If
All right.
possible.
No, I mean, we've been here since September 7th. So we're gonna go with who's here. All right. So is this gonna be contested?
Let me talk to him for a second.
All right, if y'all will step back
Yes, ma'am.
and just let the clerk know when you're ready to approach.
Yes, ma'am.
Who's here on Devon Strike?
Strike, Your Honor. We're
Strike.
here, Your Honor.
Hello.
Hello.
All right, let me just pull up your report just a second. All right, court is calling 2022 CR 7549, State of Texas versus Devon Strike. Could I have parties announced for the record for the state?
Jason Garrett.
Vince?
Adam LaHood for the defendant, Your Honor.
All right, and are you Devon Strike?
Yes, ma'am.
All right, you entered a plea on September 5th of no contest. And there was a request for a PSI and TAP evaluation. According to your plea bargain agreement, the state is recommending deferred adjudication. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
All right, any objections to the PSI report?
No, Your Honor.
No objections. Just one question. They said a DDRF and mixed screening was set for, I believe, today, say the 26th.
Yes.
I didn't know that was done. That's, other than that, it's not an objection, Your Honor. I was just curious if it was completed.
No, if it's scheduled for today, it's not completed.
That would make sense.
Yeah, no problem. So have you had a chance to review the TAP evaluation as well?
I have, Your Honor.
Any objections to the TAP evaluation from either party?
No, Your Honor.
Nothing in the public defense, Your Honor.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. We're here, Mr. Strike. He took responsibility for the action. He acknowledges he messed up, Judge. We're hoping the court will grant him deferred. Obviously, he completes it, and have a very good outcome for him. Let him avoid a felony record and felony conviction for the rest of his life. He messes up, he's facing up to 2 years in state jail, which is day for day. He understands how serious this is, Your Honor, and respectfully would ask the court to follow the plea and grant him deferred adjudication today.
All right, Mr. Strike, is there anything you wish to say?
No, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Devon Strike.
All right, do you have any support system, family, or are you just on your own?
I have a support system.
I'm sorry, who?
I have a support system.
All right, who's your support system?
My mom, my girlfriend.
All right, do you live with your mom?
No,
Who do you live with?
my girlfriend.
All right, and how old is she?
28,
All right, and how old are you?
21.
All right, do you all have children?
Yes, ma'am.
All right. I remember this case. That's why I asked you that. So if you're drug tested today, what are the results going to be?
Negative.
All right, when's the last time you used?
Never. Well, not never, but a long time ago.
Well, I mean, you're,
Since the day of the arrest.
So you're saying that you haven't used and you were not using the drugs that you're here for today?
Hmm.
You're gonna have to say yes or no.
No, ma'am.
Are you employed?
No, ma'am.
So you're not supporting yourself.
No, ma'am.
So how are you surviving? And when I say surviving, if you don't have employment, you have to eat, you have to drink water or drink something. You have shelter, obviously. So how are you supporting yourself? How do you eat? And when I say how do you eat, how are you getting food?
My girlfriend,
All right. And how old is the child?
she's 5 months,
And is she in daycare or what?
you know,
So where is she now?
at home.
With your girlfriend?
Mhm.
Okay, you need to say yes or no. And does your girlfriend work?
Yes, ma'am.
And what does she do?
She works from home.
Why don't you have a job?
Because I'm waiting on a disability check to see if I'm qualified.
All right, have you put in for disability?
Yes, ma'am.
And what's your disability?
I have schizophrenia.
Okay. All right. Did anybody see whether or not he would be a good candidate for mental health court? Was that even looked at? And the reason why I'm asking, I see his criminal history, but let me just tell everybody what my concern is. My concern is, obviously, there's an issue with him staying on his medication. We have a 5-month-old at home. The girlfriend works. I'm not saying anything will happen with the 5-month-old, but I think we all know things can happen with a 5-month-old if you have somebody with schizophrenia. And I do not have the support to monitor him the way mental health court would monitor him, or to monitor him, with probation. They can only do so much because they have a heavy caseload. And if he's in mental health court, they can do more. So that's my concern. So I don't know if anybody else has those concerns. I don't know if anybody wants to see if he would be accepted in mental health court.
What would be involved in that, Judge? I'm not too familiar with the process.
Oh, they report weekly to mental health court.
Okay.
They would probably get a case manager, which he needs a case manager to make sure he stays on his medication. Are you on any medication?
Yes, ma'am.
All right. Do you have a case manager?
No, ma'am.
He needs a case manager to make sure he's taking his meds. And this has just been my experience in having clients who had mental health issues, is that they start feeling great, then they stop taking their medications. And the reason why they stop taking their medications is because there are side effects and they don't tell their doctor about it. And then the next thing you know, my client will be back in court for another criminal case because they're not on any medications. So that, coupled with he's trying to get SSI for his mental health issues, the mental health court would have people that will be able to help him with that. So I don't know if you all want to discuss that. I don't know if, based upon his history, state if you want to consider that or not.
I haven't looked at his history of late, Your Honor.
All right, well, what I see on this is there was a misdemeanor assault case, evading to detention, and he received probation for both of those, and probation in the assault case, and it was dismissed, I'm assuming because he completed probation. And then the evading arrest, his probation was terminated. And then resisting arrest, probation was terminated. And then we have this.
Yeah.
So I don't know if y'all want to look at that. I don't want to set him up.
Well, the state wouldn't be opposed to this.
Okay, because I don't want to set him up for failure.
We're not opposed, Judge.
All right, so if you will go, Ms. Ferguson, can you see if they can do a referral for mental health court for him? And then we'll reset it, do a referral for mental health court. And then if he's accepted to mental health court and you all want to do a motion for new trial, We'll hear it, and if there's no objections, then, because they don't accept you if you have
A plea.
any case,
Okay.
yes. All right, Adam, if you will wait, Mr. Strike, Mr. Strike.
Hold on.
Hi. So do you understand what's going on?
Not completely,
All right, so
I'll talk to
you'll
him.
talk to him?
Yeah.
All right, and if you could tear up the trial court certification for me.
You're good. So, have a seat. I'll talk to him.
And Vashan, does he still have the MIC evaluation scheduled today or no?
Yeah.
Okay. All right, can you let them know that he was here? Yeah, we'll see if they'll accept him. No, felony. Because this is a possession less than a gram. Isn't that what he pled to?
I come on, strike.
Yes,
It was a possession less than a gram.
yes. With Judge Rangel. All right. All right. But we've had a couple of people who end up at. Yes, yes. Yes, yes. All right.
All right, so
Yes, okay. Because we're all on the same page.
Yeah.
all right, so where do I need to go?
Okay. And Norma, what date do you want to bring this back? Yes, we can. And if he's accepted before then, just let us know.
Yeah, definitely. So is it kind of like the misdemeanor one where if they're accepted, then that's it basically?
Yeah, then they will go there.
Good deal.
Yes.
Well, yeah, lots of motion for new trial.
I just let her. That.
So this is through the 379.
We really don't have the support staff for what he needs, because he will really need to see somebody on a weekly basis to make sure he's on his net. And he really needs a case manager for that.
And it's still on.
Mhm.
Yeah. Yeah, it's a heavy rain.
Oh, it will go there. And the only time they come back here is if they are kicked out of the program, or either they graduate. If they graduate, I go to their graduation.
Kids keep growing.
Yes, there is. Oh, Caroline, I'm sorry. Chandler?
All right.
Okay. All right.
I'm just working on the dismissal forms, Judge, for, I mean, not for the whole thing, but we're gonna TIC some cases as part of our agreement, so that's the only thing. Yeah.
Okay, so we're not gonna hear the rest?
Oh, okay.
All right.
We're ready, Judge, sorry.
All right. Did you all do a trial court certification?
I know this all.
Oh, it's over on the wall.
All grasses and all. I really, kind of depends on the weather's doing. Yeah, Raggy was strapped behind, shaking the start. And the whole slide.
All right, thank you. Court is calling 2022 CR 2006 State of Texas versus Christopher Ryan Chandler. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
John
Defense?
Robertson for Mr. Chandler.
And are you Mr. Chandler?
Yes, ma'am.
Right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I do.
Are you the same Christopher Ryan Chandler who was placed on deferred adjudication in 2022 CR 2006 for the offense of evading arrest detention with a vehicle on June 16, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
This is on the supplement, Judge. It's
Just 1 second. I don't have a supplement. All right, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that as well, Mr. Chandler?
Yes, ma'am, I do.
And did you understand it?
Yes, ma'am, I.
All right, state.
violated condition number 4 in Bexar County, Texas. The defendant, Christopher Ryan Chandler, did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
State.
Your Honor, we waive the other violations alleged in the motion to enter adjudication.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am, I was.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor.
Your Honor, we're asking, the defendant is, we're asking you to adjudicate the defendant guilty. We're going to dismiss the underlying violations alleged in the original motion to enter adjudication of guilt, and 4 years to do, Your Honor.
All right, is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will grant the motion, find you guilty, sentence you to 4 years in the prison, give you credit for any time served. All right, is there anything else with regards to sentencing?
No.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. How old are you?
24.
You're going to have to start living your life better. Otherwise, you're going to find yourself in and out of the prison. You understand?
Yes, ma'am.
Don't be that person who's the oldest person at the prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
So I first later with you.
Sure. All right, who is here on Megan Wilhite? Hello.
Good morning.
Yes, ma'am.
All right, the court is calling 2020 CR 2272 State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Will Height.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, did then and there failed to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, miss.
And Judge, it's going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, miss.
Your Honor, state waives all the violations.
Any objection?
No.
All right, did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go open to the court. The state was going to recommend 6 years TDC.
All right, so the state is asking for 6 years, defense?
Judge, I don't know if she was just sworn. Can I have my client testify briefly?
Yes. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Megan Hayes Will Height.
All right.
Megan.
Just one moment. There's Rattling. All right, who are these people? Are they on the docket? The only people who are allowed in the courtroom are defendants. Sorry about that.
It's okay, miss.
Megan, you understand the state is recommending that you go to prison
Yes, sir.
and you're asking the court to send you to safety.
Yes.
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that SafeP would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug choice?
Marijuana and methamphetamines.
Okay. When did you first start using marijuana?
When I was about 14, 15,
When
and
did you start using meth?
methamphetamines about 32 years old,
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle, and I had my belongings taken from me from an individual that I was living with. My phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just scared to go up to the probation office at that point. I already knew that I had MTR'd, and I was just scared.
Okay. You understand that you could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes,
Okay,
sir.
but you didn't do that, right?
No, sir.
So you were placed on probation when, like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamines.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Wilhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions
Yes, sir.
and you didn't go?
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't, I guess in the, how would I explain this? they had me doing certain things at a certain time and I'm sorry, the outpatient wasn't at that time that I was going. I was going to classes downtown. But it wasn't treatment at that time.
Pass the witness, Judge. No further questions.
I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right, so what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right, why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right, so this is what I'm trying to get to. One, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. Did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was going to be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm going to take that as a sign of disrespect. But it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am. No, not that it wasn't available. It's whenever I was with Ms. Martha Reyna, we were setting everything up. She had me doing the classes at that time and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available because it was part of my agreement, but it just, she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge. No, Judge.
All right. Probation.
Yes, Your Honor.
What is probation requesting?
Your Honor, the recommendation on the court summary is if she is not revoked, then to send her to safe P. I would like to point out this is her second MTR. And as she stated, it looks like she may have maybe entered the theft classes, but they were never completed.
Okay.
So at least we don't have record that they were complete.
All right. Anything else from either side?
Just brief argument, Judge.
All right, then I'll hear argument. State you are requesting 6 years.
Yes, Judge.
Is there anything you wish to add?
Judge, it's just, she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right, defense.
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhite's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if safety is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her the treatment so she doesn't continue to use methamphetamines.
All right. Anything else from you, Ms. Wilhite?
No, miss.
All right, Ms. Wilhite. The problem is, it appears that you have started things, but you have finished nothing. And the problem is, you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? We have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
Okay. All right, I'll sentence you to 5 years in the prison. Give you credit for any time served. Is there still restitution owed? Because there were several people
Yes, ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
Honor, No, no.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. And let me write those down. If you would like, what I can do is I can recommend for you the therapeutic community. I am not in charge of whether or not they give you or place you in the program. You'll have to still request it, even though I put it on the form recommending it. It will not increase the length of time that you are in custody. So for example, if you're coming up for parole in 2 years or whatever, and you have not completed the therapeutic community portion of it, they're not going to say, well, we're going to give her parole, but since she hasn't completed the therapeutic community, we're going to keep her. That's not the way it works. It's just there for you while you're there. Would you like that?
Yes, ma'am.
All right, so I'll order therapeutic community. You're still going to have to ask for it, okay?
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. And state has tendered dismissals in the misdemeanor cases that are pending. All right, is there anything else?
No, ma'am.
That's it.
All right, good luck to you, okay?
Thank
You're
you.
welcome.
I think this one here. Yes.
All right, Kevin Owens. Hello.
Judge,
Hi, how are you doing today?
just to notify the court, I've been talking with Mr. Wilkins, and my client has notified me he's never received an offer, so we're at this moment, at least talking to negotiate, see whether, they will make him an offer, and then I'll relay that to my client.
All right, so do y'all want time to do that in court now?
Well, he's gonna be bringing the file.
I think there's before I had the case, I think there was an offer that's at least written in the file,
Okay.
and probably before Mr. Castellano was on the case too, maybe. Or something.
I'm not aware of any.
All right, well, once you bring the file down and y'all do that, just ask to approach and you can skip in line.
Okay, Judge.
All right, thank you. Raul Paral. Yes, good morning. Okay. And probation, this appears to be an application. And Caroline, whenever they're ready on Owens, just let me know. Court is calling 2023 CR 6946, State of Texas versus Raul Paral Jr. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Good morning, Your Honor. Floyd Rivera.
All right, Mr. Rivera, if you could move over to that side. No, your client's in the center, yeah. All right, counsel, are you Raul Paral?
Yes, ma'am.
How do you pronounce your last name?
Ferran,
All right, I can't roll my R's,
a little bit, but it's okay.
but okay. All right. Counsel, have you received all the discovery and did you review that with your client?
Yes, I have. Your Honor.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
All right, I'm gonna need you to make sure you speak up so the
Okay.
court reporter can hear. And Mr. Kelly, if you all can move towards the end.
No problem.
All right, thank you. I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do. Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated third or more? That is a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he does.
Mr. Peral, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, I have.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State recommends community supervision. There should be ignition interlock for half the term, VIP and DWI intervention. Did you understand that to be your plea?
Yes, Your Honor.
Defense, did you understand that to be the plea?
Yes, it is, Your Honor.
State, did you understand that to be the plea?
Yes, Judge.
With regard to your agreement to ignition interlock for half the term, do you understand that whether or not that's removed will be completely up to the court?
Yeah.
So for example, if there are violations on the ignition interlock, everyone knows that it won't necessarily be for half the term. Does everyone understand?
Yes, Your Honor.
Okay. Did you understand that to be the entirety of the agreement?
Yes, ma'am.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 200 hours community service restitution, and a 2-year Texas driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offer states exhibit 1 in all attachments.
The defense has no objection, Your Honor.
You may continue to confirm. I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, I've had many meetings with my client at the office, Judge. He's 36 years of age. He's been working for HEB for approximately 8 years. He's got a very stable job. I know that the other 2 offenses were about 4 years apart of each. He understands that now he's in a whole different court, and now he's looking at up to 6 years in prison if you would grant him on this case. The time that I have talked to him at my office, Judge, he's very remorseful. He understands that he has made a bad judgment on your case. I don't anticipate that you will see him here, Judge. He has a good job, and we're asking this court to allow him to continue with his job and to grant the offer that was extended to us, Judge.
All right, do you have any children?
I do not.
Okay. Do you have a support system in place?
Yes, I do.
Who's your support system?
My spouse, my girlfriend.
All right. Have you done any sober meetings before?
I have.
All right, are you currently doing any now?
No.
Why not?
Just focus on my job right now and my life. Getting together.
Okay.
And Judge, if I may add to this, Judge, my understanding based on my meetings with him, ever since the date of the offense, my understanding is Mr. Barral has been clean. He's been very, very scared about this case. And perhaps that may be the reason why he has not, but he's very motivated to do this right, Judge. And I strongly believe if you would give him that chance, you would never see him again back in your courtroom.
All right, this is what the court is going to do. Court will sentence you to 6 years in the prison, suspended and probated for 4 years. There's a $1,500 fine that will be probated. Ignition interlock for half the term. VIP, DWI intervention, DWI education, 2-year driver's license suspension. Do a TAP evaluation, follow TAP recommendations. As far as if it recommends inpatient treatment, we're going to begin with outpatient treatment. There is to be 200 hours of community service restitution. In lieu of you're supposed to do 10 days in the Bexar County Jail. I'm going to give you a choice because I know there are issues at the jail right now. You can either serve the 10 days in the Bexar County Jail, in which case they'll take you into custody today, or either you can do that time on GPS. But since you're going to be allowed to work, you will have to be on GPS for at least 30 days. So which would you prefer?
GPS.
All right, in lieu of the 10 days at the Bexar County Jail, it will be partial GPS for 30 days. And he's allowed to work. And we'll do a waiver of deferment of fees. Proof of employment within 15 days. There should be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. And probation will do 1 field visit and then thereafter as probation deems necessary. And we'll do regular UAs and make sure there's testing for alcohol. And I'm going to order sober meetings. And I know that you're busy with employment, but I'm going to order sober meetings at least once per week. Now, with regards to the sober meetings, if you feel like you need to do more than one, because some people go to sober meetings and they're like, this is great. This is really helping me. If you feel like you need to go every day, that's not going to stop you from completing your probation. I'm not going to say, oh, he needs sober meetings every day. We're going to extend him. You understand?
Yes.
All right, probation. Is there anything else he needs?
No, Your Honor.
Judge, I have a question on
Yes.
those sober meetings once a week. For what duration of time are you going to have them do those?
Just until further notice. And if he feels that he needs to stop or he's done enough, don't approach the court until 90 days have passed. You understand?
Yes.
And then I'll consider it. All right. Is there anything else you need from the court?
No, ma'am. It's gonna be-
All right, I'm going to show you what's entitled trial court. Certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes.
All right, so we're going to go off the record. Here's the thing. DWIs are very dangerous. Nobody ever goes out drinking and say, oh, I'm going to go out and get something to drink and pick up a DWI, or I'm going to go out and drink, pick up a DWI and maybe kill someone. People never have that intent. Maybe they're going out to dinner, they're just going to have a glass of wine. Then the next thing you know, it snowballs. Since you're on probation, you're not allowed to drink alcohol at all. And that's just not because it's an alcohol offense. Everybody who's on probation, you're not allowed to drink alcohol at all. You're not allowed to do marijuana. That's the law. You understand?
Yes.
If something comes up and you feel like there's an issue you have and it's not being addressed with probation, you can always come back to this court and we can have a discussion about it. Okay? All right. Good luck to you.
All right, we appreciate your time, Judge.
Thank you. Yes.
Judge Markert,
Yes.
Megan Wilhite, she spent about 6 months in San Jacinto County, I
Mhm.
believe, when there was a hold from Bear. If I get proof of that, can we?
Yes.
Okay,
Yeah. Just bring it in to the,
I'll try to bring it in tomorrow.
okay. And what's the name of the county?
San Jacinto County,
Let me see if I spell that right. Is it JAN?
JAC.
CINTO.
Cold Spring, Texas, Judge.
Okay. And that still doesn't tell me where it's located. I'm still dealing with parishes. I'm getting there.
Okay, I'll bring it. Thanks, Judge.
Sure. Who's here on John Schulte? All right, we'll come back to you as soon as he comes in.
Yeah.
Christopher Morrison.
Morning, Your Honor.
Good morning. Good morning. So this is a case where you all are asking that he be allowed to reside in Indiana?
Yes, Your Honor.
Have you all conferred over this?
We have.
Is there an agreement or no?
There's an agreement, Judge. It appears that that's where he's primarily living. He's been showing up for every court date.
All right. So is there any concern that the complainant is in Indiana at all?
No, Judge.
There's not.
That's
Okay.
based in San Antonio.
All right. So we're going to go to record in 2023 CR 4707, State of Texas versus Christopher Morrison. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Shannon Locke for Christopher Morrison.
And are you Christopher Morrison?
I am.
All right. The court is in receipt of defendant's motion to modify conditions of bond to allow the defendant to reside outside of Texas and outside of Bexar County. Any objections from the state?
No, Your Honor.
All right. And any concerns that the complainant is in Indiana?
No, Your Honor. My understanding from reading the notes in the case is that when he spoke to our victim advocate, he's based in San Antonio. He's changed apartment, so he's here in San Antonio.
All right. So the court will grant the motion. All previous conditions that are on file, those still remain. So if there's a no contact order in place, that no contact order still remains. You understand? And is there any drug testing or anything of that nature?
I check in once a week with the Mrs.
His pretrial officer.
Oh, okay. Well, here's the thing. We were here for today is supposed to be plea deadline date in VTC. If he's not going to be living here, he's not going to be eligible for VTC. So unless they have VTC in Indiana, if you want to check on that.
And they do not, Your Honor.
Okay.
And so that we have checked on that. And there's no way for us to work out a VTC solution to this case. So we're looking at other options.
All right. So is this going to be a jury trial? Because today is the plea deadline
So
date.
they've made a plea bargain to us. They've made an offer. They extended that today. We're still in active negotiations over that plea bargain. And so we would ask for another plea bargain date if we could get one.
All right, Ms. Ferguson. On this case, give me a 30-day reset for plea bargain. The plea bargain date will not be extended past this date.
Understood, Judge.
All right. And it's on Christopher Morrison. All right, so November 30th, on that date, you need to let the court know whether or not you're accepting the offer. You understand?
Yes, sir.
All right, is there anything else?
Nothing further. Your Honor.
All right, you all are excused.
Thank you, Judge.
You're welcome. Well, after you sign the reset form. Gabriel Bernal. And Norma, can you call Mr. Young and let him know his client has shown up?
Good morning, Judge.
Good morning. How are you doing?
Good. How are you?
I cannot complain. Let me see. I don't know if that would, it should appear on the docket, Norma. All right, thank you. All right, on this case today is plea deadline date, and then there's supposed to be a motion to suppress or something. Where are we?
That's correct, Judge. I spoke to the defendant. The defendant has asked me to request more time on his case. In the alternative, I think he wants to make a request that he needs want to hire somebody else or have me dismissed of the case, Judge.
All right, well, the dismissal of your attorney, that's not going to happen. So if you want to hire an attorney, you're more than welcome to do so. Do you understand?
Yes, ma'am.
All right. I don't know what's going on with your relationship with your attorney, but what I
don't know why he put it like that.
I'm sorry, what?
No, he's good. I don't know why he put it like that.
Oh, okay. All right. So he is fine with you.
Oh, okay.
I
Okay.
just need more time.
All right. More time, what, to make a decision?
That and because when I got transferred from juvenile, that I had a case, they told me they were gonna try to get, and the prosecutor was gonna talk to this prosecutor. So I was just waiting for that.
Oh, have you talked to the prosecutor in juvenile?
I haven't. I was at the juvenile courthouse yesterday, Judge, on an unrelated matter, but nobody was like, hey, Hank, we want to talk to you about this case. So I mean, I just don't know who to.
All right.
reach
Who's
out
the
to.
prosecutor? Do you
I
know?
don't even know her name.
Oh, so it's a,
Judge named
oh, what's the judge?
Judge Valdez.
All right. So it's a female prosecutor then.
Yeah, it's a
In
female
juvenile.
prosecutor.
So,
I got transferred. I had to do like, it's because I've been on probation since a long time.
oh, so you were already on probation as a juvenile,
Right now.
as a juvenile.
And I got transferred to county.
Okay. All right, then. So how long do you think it'll take you to get in touch with the juvenile prosecutor? And we won't be doing it today.
I mean, if you could ask the defendant and counsel to stick around, I can make a phone call and see what's going on. This would be if I call over there and they're like, yeah, that's what's going on, then we can, maybe resolve this today.
Okay.
And if it's not, we can get a new date. I do have the witnesses here for the motion to suppress, and I would like to release them if I can.
All right.
It's up to the court, Judge. I just.
No, I mean, it's up to defense. Do you still want to have a motion to suppress or no? He says he has witnesses here.
Can I talk to my client?
Sure. And go ahead and see if you can call the juvenile prosecutor. They may be busy because it's morning for them as well. And then you need to talk to your client about this motion to suppress, because either you're going to be waiving the motion and it's not coming back as far as pretrial is, maybe during the trial, but not as pretrial. You understand?
I understand, Judge.
All right.
That's why I want to make sure he understands.
Okay. All right. Thank you.
Thank you, Judge.
Kavonda Jackson and Deputy Laura. My mom had a long conversation with me, so we will be recessing exactly at noon.
I already texted everyone.
Thank you. All right. Court is calling 2021 CR 5896A, State of Texas versus Kavonda Jackson. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Ray Lopez for the defense.
All right. Are you Miss Jackson?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I did.
Are you the same Kavonda Jackson who was placed on deferred adjudication in 2021 CR 5896A for the offense of possession less than 1 gram on November 18, 2021 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant, Javonda Tanae Jackson, did then and there fail to report to the supervision officer as directed for the months of August and September 2022 in violation of condition number 5.
How do you plead to that? True or not true?
That is true.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
All right, court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Judge, SATIV followed by aftercare and a 1-year extension to her probation term.
Is that what you're requesting?
That is, Your Honor.
All right, Ms. Jackson, do you understand what both parties are requesting?
Yes.
So they want you to go into inpatient treatment. Here are your choices. You can go into inpatient treatment or either I can revoke you. Sometimes I can't give people choices, but I will give you a choice. Here's your choice. You can go to SATA, hopefully get your drug issues resolved where you can be clean and sober. I see where I said CPS compliance, so obviously there's children involved. So you can either do that or either I will revoke you and sentence you to 18 months. Which would you prefer?
So,
All right, the court will deny the motion. And Ms. Abrams, we'll refer her to SATIF, but however, if there's some mental health issues, then she'll probably need to go to SafeP. So I'm going to deny the motion, alternate amend conditions to include SATIF, and if not accepted at SATIF, then it'll be SafeP. And I'm going to extend her for 1 year. Is there anything else you need from me, Ms. Jackson?
no, ma'am.
All right, good luck to you.
Thank you.
You're welcome. All right, are we ready on Kevin Owens? I'm thinking not. Oh, you're not on Kevin Owens, are you? Okay.
This is my phone. I apologize. That's not what I-
Who's your client?
John Schultz.
That was up next.
Oh, okay.
All right,
Thank you.
you're welcome. John Schulte? Yes.
Good morning.
Good morning.
Oh,
And probation, this is an application. Court is calling 2023 CR 6701, State of Texas versus John Schulte. Can I have parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
Jody Sawyers.
And am I pronouncing your last name correctly?
You did, yes.
All right, thank you. Are you John Schulte?
Yeah.
Okay. Counsel, have you received all the discovery in this case?
Yes,
And did you review it with your client?
I did.
All right, the court will find that the state is in compliance with discovery. Mr. Schulte, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did your attorney, did you understand it and did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes,
State, are you proceeding on the indictment as presented?
Judge, we are going to reduce this to the misdemeanor deadly conduct, and we were going to waive the deadly weapon allegation.
Any objection?
no objection.
All right, and with regards to the discovery, I saw a notation that the
there's a large file that
Yes.
we weren't able, we don't have it, but there's a lot of videos that overlapped. And so we have everything that we needed to be able to analyze the case.
All right.
And Judge, I did make defense aware, there was gunshot residue that wasn't tested. I did reach out to the police department. They were going to test it. And we're still awaiting those results, but I did inform defense of that.
All right.
And we don't have it currently, but we've decided to proceed without it.
All right. So Mr. Schulte, knowing what has just been discussed, do you still wish to proceed with this plea?
Yes, please.
All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of deadly conduct as a misdemeanor, Class A? Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine. Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Schulte, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of deadly conduct misdemeanor. They're asking that there be a $200 fine and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes.
Defense,
Yes,
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
there have not.
Showing you outside the agreement, state is recommending that your deferred adjudication be for a term of 16 months. There be a TAP evaluation, 100 hours of community service restitution, and no contact with Sally Talamontes, Ernesto Roberto Quintero, Paul Garcia, regular and random UAs. Did you understand those were recommendations from the state? That's okay. And the court does not have to follow those recommendations.
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states Exhibit 1 in all attachments.
No objection.
You may be excused. Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would like the court to know that he has already taken an anger management class as well as an alcohol awareness class. He has a master's in bachelor's in mechanical engineering, sorry, the M words confused me. And he is an HVAC technician. He travels throughout the state of Texas, so we would be asking for permission to travel without permission throughout the state of Texas for his job. And then also.
All right, everyone, please whisper.
On community service hours, we would be asking that those be 48 hours and that he be granted the right to buy out of those.
All right. So is there an issue with your neighbors?
No,
All right, do you still live in the same location?
excuse me for that. There was, they have since moved away. There's no dog in my backyard anymore. All that's resolved.
Okay. All righty, because whenever firearms involved, things can go south pretty quickly.
Yes.
You understand that?
Yes.
This is what the court is going to do. Court is going to sentence you to a $200 fine. That will be probated. Where is Fashawn? I don't see. Okay, thank you. I'll sentence you to 1 year deferred adjudication. 100 hours of community service restitution. If you would like to buy out of that, you're more than welcome to. It'll be at $7.25 per hour. And Vashan, he can do it to the food bank. And I think there is another email that was sent to us for another program as well. And if those programs, you don't want to donate to them, but there's another program you would like to donate to, just let probation know, and we'll see if that will be allowed.
Thank you.
There is to be no contact with Sally Talamontes, Ernesto, Roberto Quintero, and Paul Garcia. Are these the people who you said no longer are there?
That I'm not sure.
He does not know their names, so he would never have been able to find them. I mean, assuming from the police report, those are the people that live there. He is aware that his neighbors have moved. He has no contact.
So you're not to have any contact with these people, you understand?
Yes.
All right. There's to be proof of employment within 15 days. No employment as a home health care provider or with minors. The defendant is allowed to travel for employment. And there's to be regular and random UAs. I'm going to order anger management. And if he provides proof that he's already taken it, probation, you can accept that. And I'll order the alcohol awareness course. And if he's already done that, you just provide proof of that. Do you understand?
Yes, ma'am.
There's to be regular reporting by Zoom or in person. Probation, is there anything else he needs? You can just do one field visit. And if everything seems in order, you can then do field visits as you deem necessary. All right, is there anything else you need from the court in order to be successful?
No, no.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. If there's an issue with probation, you feel as though they're not addressing it, you can always come back to the court and we will address it here. Do you understand?
Yes.
All right, good luck to you.
Thank
Just have a seat in probation. We'll get to you when they're available.
I understand. Thank you.
Okay,
Thank you, Your Honor.
you're
Have a
welcome.
great day.
You're welcome. Jimmy Barrientos And this is the lineup. It will be Jimmy Barrientos, then Shalice Schnitz, Gabriel Bernal, Kevin Owens, if you all are ready, and Jessica Johnson. Who? You were waiting for somebody, correct?
I did one already, but I've got Jessica Johnson.
Okay,
It's Chamber.
all right, thank you. All right, Jimmy Barrientos.
Judge, if we can just preface, before we call the case for a disposition.
Yes.
Okay, I'm sorry. Okay. We have conferred this morning, Judge, and with your permission, we want to seek medical records that probation office thinks would be important to make a recommendation on Mr. Barrientos. I brought this just to give you a heads up on why we're asking for that.
Okay. All righty. So how much time are you all asking for?
The medical records are in Nebraska, Judge. I just spoke with his daughter. He's gonna have to get a medical release to send to him to sign, so maybe 3 weeks.
All right, Ms. Ferguson, on Barrientos, if you can give me a 30-day reset.
I can do November 30th.
That works.
All right, we'll come back on November 30th. At that time, you need to have your medical records, you understand? All right, and once he signs the reset form, he's excused. Welcome.
Thank you. Kind of thinking, I'll get you out in just a second. Okay.
All right, Shalice Schnitz.
Morning.
Good morning. All right. So you have a motion to inspect state.
Judge Daniel stepped out.
All right, just give us a moment. Oh, no problem. Gabriel Bernal. Hello. Okay, all right, okay, bye-bye. All right, so we're back here. What is the update?
Yes, Judge, I spoke to the defendant. The defendant has agreed to waive the pretrial hearing today. He's asked me if we can get a quick reset so we can get in contact with the other prosecutor in juvenile, because apparently that may be a way to resolve this case.
All right, Ms. Ferguson, on Gabriel Bernal, can I have a 30-day reset? That will be your final plea deadline date.
November 30th.
All right, once you sign the reset form, you are excused.
So Judge, just to, they're on paper files over there, so I haven't in contact with juvenile prosecutors, they're pulling that file, but, so I mean, if you wanted to stick around, we could see if maybe we could resolve this today.
All right, then just remain. He said they're pulling the file.
All right. We'll wait.
All right, thank you.
Thank you.
Mariana Barnes.
I just step out and get the.
Okay.
Yeah.
No problem. Okay. All right, so after this case, I don't see Mr. Owen's attorney. So it's going to be Jessica Johnson, then Keenan Brown. So do y'all want to step back on this one? No problem. Hey, we multitask here. All right, if you guys can step back and we will take that up. Jessica Johnson. And just whenever you all are ready on that, just ask to approach. Thank you for your patience.
Yes, ma'am.
Court is calling 2021 CR 7243, State of Texas versus Jessica Lee Johnson. Can I have parties announced for the record for the state?
Hey, state, Your Honor.
Defense?
John Robertson from Ms. Johnson.
All right, and are you Jessica Johnson?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First, I'm sorry, state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. And second, state's motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jessica Lee Johnson, who was placed on deferred adjudication in 2021 CR 7243 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 8, 2021 for a period of 5 years? Is that you?
Ma'am.
All right, state.
This is on the first motion, Judge. Violated condition number 2, on or about the 6th day of February. I'm sorry. Violated condition number 4, in Bexar County, Texas, the defendant Jessica Lee Johnson did then and there fail to report to the supervision officer as directed for the months of April, May, November, December 2022, and January 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And then, Judge, this is on the second state's motion to supplement pending motion to enter. Violated condition number 4, in Bexar County, Texas, the defendant Jessica Lee Johnson did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, and August 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And Your Honor, we've waived and abandoned the other violations alleged in the motions.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of conditions 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find violations 4 and 4 true. Is there a proposed agreement?
No, Your Honor.
All right, state, what are you requesting?
Your Honor, we're asking that you grant the motion, adjudicate the defendant guilty, and sentence the defendant to 10 years to do.
All right, defense, what are you requesting?
Your Honor, I'm requesting the court consider something other than revocation, or if revocation is going to be imposed at a number less than 10 would be more appropriate. Ms. Johnson would like to address the court, kind of explain her situation. She advised me that her situation recently has actually improved as far as the stability of her personal life. She's had a lot on her plate the last year and a half or so. Has admittedly not performed well on probation, but she would like to address the court and explain it.
All right, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jessica Johnson.
All right, what would you like to say?
Just now that I'm in a better stable environment, and my dad's health is a little better under control. And I was gonna try to ask for a final chance with probation being in the new county that we've relocated to. Me going away will leave my 18-year-old take care of my dad by himself.
All right, what have you been doing while you've been on probation? Because you have not been reporting.
Yes, ma'am. Well, we did move out to Pipe Creek, Texas. And my dad's health was up and down in the middle of us relocating. So we actually ended up leaving behind, half of our belongings at the old house and not even going back for it because my dad having to have surgery and being in and out the hospital.
Let me ask you this. Did you ever provide the location of the children?
Yes, ma'am.
Okay, so because this is your third motion to revoke.
Yes, ma'am.
And the first one, it's,
They're still in the same place with my mom that they've been the whole time because of my dad's health being up and down and us relocating. I didn't want to move my mom and them, to one county when we're moving in the middle of.
tell probation you were moving,
No, ma'am.
all right, because the first motion to revoke,
Right.
it was you were to provide proof of residency in Austin
Right.
and follow through on your CPS requirements. Did you complete CPS?
When I contacted them, when I got out, they said that the case was closed and there was nothing else for me to complete or do with them.
All right. Did you do felony drug court in Austin?
No, ma'am. I actually never ended up leaving. They had, my probation officer that I had went on, I don't know if it was a vacation or what, she ended up not coming back and I had got like a new probation officer. So I never even got to actually leave to Austin. They revoked it that time.
All right. Did you complete parenting classes?
No, ma'am, I didn't. With my dad and us moving, I didn't get to start anything. I did sign up while I was in the
So
county waiting.
you've been on probation since September 2021.
Right.
What have you completed?
I haven't got to complete anything else.
Okay.
That's what I'm saying now that I'm in more of a stable environment and situated and my dad a little bit more under control, I would be able to start and do everything that I was supposed to originally do.
All right. The court is finding violations 4, 4, and true. The court is going to grant the motion, find you guilty. Would parties like to speak to time? I know State, you said you're asking for 10 years.
Your Honor, I just think a more moderate sentence would be appropriate for her. She's got a lot on her plate. She's got responsibilities she needs to get back to. I would ask the court to consider a sentence closer to 2 than 10, given the situation.
Just one moment. All right, court will find you guilty, grant the motion, sentence you to 10 years in the prison. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And counsel, if she would like the therapeutic community, I can recommend that. It doesn't increase the length of time that you're in custody. Would you like that or no?
Yes.
All right. You'll still have to request it yourself. All right. Good luck to you.
Thank you, Your Honor.
You're welcome. Kenyon Brown. Who's the attorney for Brown? Hi. Hello, Mr. Brown. Oh, I'm doing great. How are you doing?
Thank you.
All right. So today is plea deadline day.
No plea, Judge.
All right. So you're asking for a jury trial? All right. So the court will not consider any plea bargain agreements in this case after today without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. How long are you all expecting this jury trial to last?
Judge, there's 4 different cases, and I believe they're different instances, so we'd probably be trying the ag robbery first, and there's 4 late witnesses, and then with everything else, probably at least 3 or 4 days.
All right,
The ag robbery?
Okay, it's a pawn shop case, okay.
all right, Miss Ferguson. They say 3 to 4 days.
I would say that's correct. Yeah,
Of course,
that's a good estimate.
Judge or jury for punishment, if we get to punishment.
So do you all know the answer to that question?
We will probably go to you for punishment, Your Honor, but 3 or 4 days is an accurate, very accurate
Okay.
estimate.
Yeah, that's, yeah. That's fine.
All right, we'll see you back on December 5th. You'll be brought over dressed in whatever clothing that's at the jail. So whatever civilian clothing that you have there, that's what they're gonna bring you over in. If you wish to be attired in something different, you'll have to let your attorney know. If
I
there's,
dress my people, Your Honor.
I know you do.
Okay.
I have seen where that has not happened, but not with you. So if there's an issue with the clothing exchange, just let the court know.
And I have to let the court know that last week, another court set a case for the four. I'm
Is it
actually
misdemeanor
in
court?
impact. No, in felony impact. And on a child sex case, and I'm also set that day on a aggravated assault with a deadly weapon set on that day. So just so I'm keeping everybody apprised.
Oh, no, I
if
appreciate
I'm
that.
not able to be here on the 5th.
We will see where we are.
Okay, thank you, Your Honor.
All right, thank you. Is there anything else?
No, Your Honor.
All right, you're excused. Is the attorney here for Kevin Owens? Jason, do you have your parties for?
Yes.
All right, then we'll take that up. Mariana Barnes.
Judge, I did talk to the victim's mother. She is coming in right now. She may try to voice
Okay.
her opinion.
Nope.
Just want to let you be aware of that, so that this not to disrupt the proceedings. She wants you to read the letter before. I told her no.
Okay. Are you in agreement with me reading the letter before?
No,
Okay. All right, and then there's a Huffman in the waiting room.
That is with Uriah Huffman, that's his mother's mother,
Okay,
and that's with Carl Alexander.
okay. All right, court is calling 2023 CR 7666 and 2023 CR 7845, State of Texas versus Mariana Barnes. We're gonna have parties announced for the record for the state.
Jason Garahan, Your Honor.
John Young for the defense.
And are you Miss Barnes?
Yes, ma'am.
All right, and Miss Barnes, I know you were late for court, but the court is excusing that lateness because of the weather and because she did call into the clerks to let them know that she was stuck in traffic. And I know that some people had issues getting to court.
Did you know that there was a tornado over off of 281?
Well, they told me there was one downtown as well. I missed it.
Just me.
All right. All right, you entered a plea of no contest to kidnapping on October 17th. We're here for sentencing. Are both parties ready to proceed with
We
sentencing?
are, Your Honor.
All right. Is there any evidence you wish to present
No, Your Honor, we request the court to follow the agreement.
and defend? I'm sorry, in state?
Yeah, absolutely. Yes, ma'am.
All right, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served, take in consideration 2023, excuse me, I'm gonna have to have you sit in the court. 2023 CR 7845. And there's to be no contact with the complainant. All right, is there anything else with regards to sentencing?
No, Your Honor.
Not for sentencing, Your Honor, but just off the record.
Okay, show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know you say you have a child and your child is young. You're gonna have to start making better decisions. I read the police report and it appears that everybody was using drugs. Using drugs and having a child does not make for a good life for a child. You understand?
Yes, ma'am.
All right, good luck to you. Is there, all right, is there a letter that I'm being asked to read?
I don't, let me check, see if she wants to read it or. Yes, no, she would like to read it.
Okay, sure. Fabian Cardenas.
Present Judge.
Thank you.
Morning.
Good morning. And just let me know when you all are ready. Yes. All right, let me take, yeah, let me take this up and then Shannon, whenever you're ready, just approach the clerk and let them know. All right. There's an application.
Your Honor, there is a new plea where we are opposed and asking the PSI. So we're asking for the sentencing from MTR to be set the same as the PSI.
All right, so is there going to be a plea of true in the MTR?
There is, Judge.
All right, so we're going to take up the MTR and then we'll take up the plea.
Yes, ma'am.
And your date is going to be December 15th to come back.
Understood, yes, ma'am.
All right, court is calling to, excuse me, could somebody take care of the person who's causing issues outside the courtroom? All right, thank you. If you will have her leave the courtroom. All righty. Court is calling 2022 CR 11171. State of Texas versus Fabian Cardenas. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Sir, do you bar for Mr. Fabian Cardenas?
And are you Fabian Cardenas?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Fabian Lee Cardenas who was placed on deferred adjudication for the offense of evading arrest detention with a vehicle on April 3rd, 2023 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, on or about the 6th day of May
2023 in Bear County, Texas. The defendant Fabian Lee Cardenas committed the offense of endangering child in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
State waives the other conditions, Your Honor.
any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Your sentencing will take place in that cause number on December 15th. Next, we're going to proceed in cause number 2023 CR 9773W. Going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to, counsel, have you received all the discovery and did you review it with your client?
I had, Your Honor, and we did.
Court will find that the state is in compliance with discovery, showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, are you proceeding on the information as presented?
We are, Your Honor.
Going to show you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're going to be charged with the offense of injury to a child recklessly as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
All right, I'm just being told that your date is going to be December 14th instead of the 15th.
Understood, yes. Ma'am. And Your Honor, briefly, just, I know that it's all in the documentation there, but Your Honor had said injury to a child. Our understanding is it's endangering a child is the.
Oh, I'm so sorry. It is endangering the child.
And he was aware of that.
All right, so the charge is endangering a child. Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, to both.
Mr. Cardenas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the state is requesting that your punishment be assessed at 2 years in the state jail facility, and they are opposed to your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
Yes, Your Honor, state offer states, or I apologize. Yes,
All right, showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it
Yes, ma'am.
in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Council, have there been any such motions?
No, ma'am.
Then to the offense of endangering a child, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence
Yes, Your Honor. State offer states one and all attachments.
No objections, Your Honor.
showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you've applied for deferred adjudication. We are going to come back on December 14th. At that time, the court will make a decision on your motion to revoke and also on whether or not to grant you deferred adjudication or probation. I'm going to order a PSI. Is a TAP evaluation needed?
I don't know that it is, Your Honor, but if it helps the court with any information.
All right. Based upon what I reviewed in the police report, I'm going to order a TAP evaluation.
Understood, Judge.
All right. Is there anything else?
Nothing further. from the
All right.
defense.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Are y'all ready on snips? All right, in any file that I don't currently have now, you are gonna have to come back on a different day. So I have Kevin Owens, Ernest Morales, Uriah Huffman, and Norma. They'll have to come back in the afternoon. Those are the cases that I have. Court is calling 2023 CR 5651, State of Texas versus Shalise Schnitz. Am I pronouncing your last name correctly? All right. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense
Shannon Lock for Shalish Schnitz.
and,
It's Mr. Javier Garcia.
all right, is he on the case as well?
Yes.
All right, you want to announce for the record?
Javier Garcia, Your Honor.
All right, so I have several motions before me. The first is the motion for defense to conduct an independent analysis of the defendant's blood sample. Did y'all review that?
So we took a look. My understanding of that motion is that defense wants to get the second vial of blood taken by BCSO in this case and send it through their own lab. I mean, the state has no objection. I think that's something that they have the right to do.
Okay. All right, that will be granted. And of course, the laboratory here will have to make safeguards, and that's not in the court's purview to make safeguards for the analysis.
Right, Judge. My understanding is that the defense will have to, whoever is analyzing the blood for them will have to pick up the blood from BCSO, and there will have to be a clear chain of custody. So that's something that they're going to have to do.
That's correct, Your Honor.
That the safeguards are in place.
Quiet, please, in the courtroom.
All right, everyone, you need to whisper. All right, and then the motion to examine and test physical evidence.
My understanding, Judge, is that the defense wanted in that motion to take a look and inspect the vehicles that were involved in this case. My understanding is that they are in the Bexar County, they're in Bexar County's possession, so that's something that we can try and facilitate. It's just coordinating everything with everyone. I know that the detective in order for us to inspect, he has to be there.
All right, so do y'all still want to keep number 1 where it says that you are to produce the vehicles? Because I don't know if that's the proper wording.
Just make available to us for inspection, Your Honor.
All right, if y'all want to put in there to make available for inspection instead of produce.
You don't know. Okay.
This initial, Your Honor, that's.
Yes.
Mr. Escobar's handwriting.
Initial fee, Judge. Here you go.
All right, thank you. All right, that will be granted. And then there's a request for no broadcasting. Is that correct?
That is correct.
All right. So the court has read the defense's motion, and what I can tell the defense is, number one, the court limits the number of people in the courtroom for security reasons, also for health reasons. I think everybody is aware of the brawl, for want of a better word, brawl, skirmish, or whatever that occurred in the other courtroom. As everybody is aware, there are only a limited number of deputies. I have 2 deputies in this courtroom, and we almost had another incident here today that I think would have turned quite differently if the courtroom were packed. The court must have an open courtroom to the public, and that is how the courtroom is keeping it open to the public. So I've read your motion, and that motion is denied.
Your Honor, may I make a little bit of a record on that?
Sure.
Okay, and so Ms. Schnitz has some specific things that have affected her as a result of the broadcast over YouTube. And specifically, Your Honor, the open courts, one, we don't think that you need to close the courtroom to non-participants. So we object to the closing of the courtroom, which we were just made aware of this morning. So we have that objection. We think the courtroom should be open to live audience members. Ms. Schnitz is in a very particular situation. She's in a custody battle at the time, currently, and her ex-husband monitors these YouTube videos. He saves them and broadcasts her information to her friends and family and uses it in her child custody case. Additionally, Your Honor, sorry, I'm going to have Ms. Schnitz speak to that if she could.
Sure. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Shali Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
oh, the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very, very serious situation. And he is using the YouTube videos, and he's explained that in emails to watch what is happening on court to find the location of my daughter. And I'm sorry.
So also, he would come in person before, correct?
Yes, sir.
Okay, and now he knows where you are because he can watch the broadcast. Is that right?
Yes, ma'am.
Oh.
I mean, yes, sir.
Okay, and when you additionally, you've had to talk about your treatment situation. You're addressing your alcohol issue. We've had to do that in open court previously. Is that right?
Yes, sir.
And has he recorded those to your knowledge?
Yes, he records those as well.
And he lets other people know who are involved in your case?
Yes, he lets over 20 people know and places it on social media and sends it out.
Okay, and that's everywhere from Governor Abbott to Joe Gonzalez to everybody that is also the principal of your daughter's school. Is that right?
Yes, sir.
Okay. And so at this point, you're left with a choice of either terminating these proceedings by entering a guilty plea or continuing to be broadcast on YouTube.
Yes.
Okay, and that's the choice that you're currently facing. Is that right?
Yes.
Okay. All right. Do you want to be broadcast on YouTube?
No, sir. It's very scary for me. Terrifying.
No, that's all right. I have no further
Any
questions.
questions?
Nothing to say, Judge.
All right, and the court will state again, everyone is aware of the brawl, skirmish, whatever you want to call it, that took place in this courthouse recently. No less than, I think, 10 deputies or maybe more were summoned. There was a fight in the jury box where audience members came from the audience and attacked someone, and I will use the word allegedly, but I think everybody is aware of it, an inmate that was in the box. We just had what could have been a bad incident in this court today where deputies had to step in and escort somebody out of this courtroom. This is a court that needs to be open to the public. I am not going to allow people in the courtroom for safety reasons. I'm not allowing people in the courtroom unless they are a defendant, a person accused, or unless they are a witness, and those witnesses will be brought in when they are needed. The state will tell you, and other persons in this courtroom will tell you, anyone who is given victim impact, they can come in when it's time for them to give victim impact. But that is the way this courtroom will be run. So for security issues, we only have 2 deputies in a courtroom, and we have a third, I'm sorry, sort of a third. And I say third because he's wearing his jacket, right? But he's not assigned to this courtroom. So when you think about it, right now we have 1, 2, 3, 4, 5 people in the box. And really normally only 2 deputies. And sometimes we have 10 people in the box. So the motion is denied. And we're going to come back
Your Honor,
on December 12th.
just one other question. Could you admonish people not to record the broadcast?
Oh, people, I am not in charge of broadcasting.
But so what
So-
happens is people will capture, like they'll capture this event, they'll put it on other platforms.
And what I can tell you, counsel, is in this courtroom with your client, I have never asked, nobody's ever asked, if I'm wrong, tell me I'm wrong. Nobody's ever asked what school her child is at or asked any of that nature. With regards to a civil case, that's something that needs to be addressed civilly. This is a criminal court.
But what happens, Your Honor, and the problem is that this is now, the YouTube broadcast is as much an official record as the court reporters.
No, it's not. The court reporter's record is the official record. I made my ruling. You all are coming back on December 12th. On December 12th, I expect everyone to have their discovery in order. If there's more time that's needed to look at a vehicle, let the court know. If there's some issues with the blood, let the court know before the December 12th setting. All right, Ernest Morales.
Thank you, Your Honor. May we be excused?
Yes, you may be excused after you sign the reset form.
Thank you very much.
And on Ernest Morales. Yes, are you all ready to proceed?
No, Judge, I let the clerk know, I got a text message this morning from Sarah May. She hasn't completed the Padilla letter. She did have an interview with Mr. Morales.
Okay, all right, Ms. Ferguson, I need a reset because they haven't done the PID letter isn't completed.
They can come back on November 30th.
Yes,
Your Honor, like I was telling my lawyer, like I did have an interview with the other lawyer. I want this to be done today. I mean, I already know the process. I already know what could happen if I'm found guilty or whatever, you know what I mean, that I could get deported, you know, just like I told the lawyer, I'm okay with it, you know what I mean?
all right, I understand what you're saying, but let me just tell you the position that the court is in. This is the position that I'm in. Legally, when someone is not a citizen, they have to be advised by an immigration attorney. I know you say, you know what will happen, but that's not the way it works in legal world, because if I were to go forward with this sentencing, even though you're saying, I know what's going to happen, you know what would end up happening? If you decided to change your mind, you could come back and guess what? We would have to start the whole process over again. And guess what they would say? Judge Boyd, you know that person has to be advised by an immigration attorney and you did not do your job. So
I was advised. I had an interview with the lady yesterday, and I told her, you know what I mean, like it'll be okay, you know. She said okay, that she was gonna.
Yes, but there's case law on file that says that there has to be a Padilla letter on file, and she hasn't had sufficient time to prepare for that. She worked for the public defender's office. She has a lot of different cases and I'll
Well,
explain that to you.
Then why won't she tell me that she was already gonna be ready, you know what I mean, like, cause I told her that I didn't want this to expect tomorrow's date, you know, just today. You know, why would she tell me it was gonna be done,
All right.
you know what I mean?
I understand what you're saying.
And now
I
I'm
under-
here in front of you, you know, and.
Here's the
and
thing. I understand what's going on. I understand your confusion. Let me ask you this. How old are you?
I'm 42.
All right, you're 42. This is what I would always tell people. When you're dealing with children and you make a promise to a child, you need to keep that promise because they don't understand when other things come up, but we're adults. So I want you to internalize the fact that this case is not going today. And the reason why it's not going today is because of legal reasons. Do you understand?
Yes, Your Honor.
So your attorney, she could say, Judge, I want to go forward now without that information. And you know what I would say? Not doing it. And you know why your attorney is not going to say she's going forward without that information? Because guess what? That would be called ineffective assistance of counsel. And if you decided to come back later on and want to do an appeal, guess what? It will be granted for those reasons. So we'll see you back on the 30th. If she has it before the 30th, let the court know.
Yes, Judge, I will. I'll ask, I'll try to get it.
All right, thank you. Huffman. And then after that, we have Robles, Martinez, and Owens, and everything else will come back the afternoon.
Judge, we do, just if you have a moment, that Rose, my advocate's getting the victim and his mother.
Okay, and then I will let Ms. Huffman, she's on Zoom?
Yes, ma'am.
All right,
No objection.
all right, thank you.
I'm gonna
Yes, I'm having her Zoom in.
apologize for my sniffing or coughing, Judge. I have a bit of a sinus infection. I tested myself. I'm free of the nefarious virus.
All right. You know, I just got my flu shot and it, whoa.
This is a yearly occurrence with me. Like, I know the feeling all too well.
All right, Ms. Huffman, are you able to hear us?
Yes, I can.
All right, so Ms. Huffman, this is the way this proceeding is going to work. You're not allowed to talk until someone actually calls you as a witness. You understand?
Yes, ma'am.
All right, so if you'll place yourself on mute for me, please.
Okay, how do I do that now? Oh, okay.
All right, court is calling 2022 CR 7209, State of Texas versus Uriah David Huffman. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Carl Alexander for Mr. Huff.
And are you Mr. Huffman?
Yes, ma'am.
All right, you entered a plea of guilty on September 11th. You applied for deferred adjudication. According to the plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There are 2 cases that are being taken in consideration. There's an affirmative finding of deadly weapon, a $5,000 fine, and the state is opposing your application. And there is restitution to Joshua Sandoval and Ramon Lavario. Have both parties had a chance to review the PSI report?
Yes, Your Honor, the state has.
Yes, ma'am.
Any objections?
There's a few corrections, Judge, but I think we can handle most of that during testimony.
All right. State, do you have any witnesses? Okay.
The state will have any witnesses.
All right, defense, do you have any witnesses?
Yes, Your Honor. I guess first I'll go ahead and take care of the Zoom witness called Candy Huffman.
All right, can you unmute yourself, please? All right, any objections to the witness appearing by Zoom, state,
No, Your Honor.
defense?
No.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. State your name for the record, please.
Candy Joanne Huffman.
Defense. Thank you. Your Honor. Ms. Huffman, although I think we can tell by your last name, how are you related to Uriah?
I'm his mother.
And how old is Uriah?
26. Oh, God.
Have you not seen Uriah in a while?
No,
Where do you
I-
currently?
I also have lupus, and so memory and stuff is a little, I had to think about the math.
I got you. Okay. Where do you currently live at?
I live in Florida,
Can you be a little more specific, at least what county?
Orlando. I live in Orlando.
Uriah, he's originally from Texas, is that right?
Yes, he was born in Dallas.
And was there a father in his life?
No,
Has he ever known his father?
no, he's never met him. He left, rather, I left him when his father, whenever I was 4 months pregnant.
Does your son have a drug problem?
He did. Yeah,
And you say he did, are you talking about the fact that he's been sober since he's been in jail for a year and a half?
yes, I suppose.
Okay, so prior to his arrest for the offenses that brings him here today, how bad would you say Uriah's drug use was?
I would say probably pretty bad. As far as what I was aware, he was always high.
Did he choose to be homeless in order to feed that addiction?
I think that I don't think he chose to be homeless in order to feed the addiction, to be honest. I think he chose to be homeless, and the addiction, or the drug use rather, was just part of it because of the people that he was around.
So during this time, the time that Uriah took part in hurting people, was he the same Uriah that you knew and raised?
No, absolutely not. Uriah was never violent. Even whenever I found out about what happened, I was shocked. He's not a violent person. He was never in fights at school growing up. He never at all. He wasn't violent at home. He didn't punch walls. He was never like that, ever.
Now, since his incarceration, have you had contact with him, either through
Yes.
phone, video visits?
Yes.
And have you seen Uriah change over the course of the last year and a half?
Yes, other than just being understandably sad and depressed and lonely, as you would be in the situation that he's in. I got my son back. Became I could talk to him again. He could carry on and wanted to carry on a conversation with me. He was back to being my loving son again.
Now, if the judge grants Uriah deferred adjudication, okay, will he have a place to live?
Yes, he can live here with me.
So that would be in Florida.
Yes, sir.
And again, if he's granted deferred, there's probably going to be a lot of requirements of him, such as making appointments, being tested for substance abuse, probably doing some type of classes of community service.
Mm-hmm.
Will you aid him in making sure he's complying with all of the requirements?
Absolutely. Yes. I work from home. Well, I am starting a home business. I'm an artist, so it's just crafting, but so I'm free to do that.
Will you help Uriah in getting employment?
Yes, absolutely.
Does he actually have a job waiting for him in Florida if he is granted probation?
Yes, my husband had spoken to but he told me, now this was a while back, that he, sorry, my hand is cramping, that he could have an entry level position with my husband.
And what would he be doing?
Just computer work. I'm not really sure exactly what it is, but it would be just stuff on the computer. Other than that, if that isn't still available, because he hasn't talked to his boss about it recently, then, you know, I would do whatever I needed to do to help him find a job. That would definitely be a priority.
And again, if Uriah is granted deferred adjudication, he's very likely going to have to make restitution to the victims of his cases. Would you help him make sure that he stays employed and he's making good on that debt?
I would do whatever I needed to do to help him do what he needed to do. Yes. My husband and I would, my mother and father would. I've already talked to them about it as well. My mother and stepfather also live here. That's why I moved here. And they're also supportive. So
that's a support structure that Uriah has there in Florida. Did he have all that here before when he chose to get lost in drugs?
He's always had me, but no, not really. Other than me, no.
But so now it's a bigger support structure waiting for him.
Yes, I would say so. But he also he won't know anybody here. Like nobody from, you know, anybody that he used to run with or know on the streets or anything. Like he won't know anybody here. So it would be a complete fresh start, you know, and as far as that goes, I think that would be a great help as well. And that's just my opinion, but yeah.
All right, Ms. Huffman. Thank you for your time. I'll pass the witness.
I'm sorry, state.
Thank you. Ms. Huffman, I'm Jason Garahan. I'm a prosecutor for the state of Texas.
Yes, sir. Hi.
Hi, nice to see you on Zoom here. I got the indication that you're, when Mr. Alexander was asking you some questions that, tell me if I'm wrong, but Uriah's violence towards other people was sort of a drug induced. Is that what you feel?
Yes, I think that it was drug induced and that and because of who he was with, more than anything.
I mean, you are aware that there's a evaluation, what we call a precedence investigation, where your son stated that he denied consuming alcohol or drugs during the commitment of this offense of aggravated assault on an individual. Are you aware of that?
No, I'm not, but I know how methamphetamines work, and I know my son, and he wasn't the same person at that time.
Were you there?
Mentally?
Sorry.
No, I wasn't. I obviously wasn't there, but I talked to him often. Well, sometimes I went and talked to him for a month or two, but I mean, I talked to him that day, the day that he got arrested, and I could hear it in his voice.
Did you know that if he actually didn't get arrested on the day of the offense?
No, well, no.
In his precedence investigation, he said he did meth after the offense happened in the days following. You're not aware of that, are you?
No.
And are you aware of the victim's injuries in this case?
The victim's what?
Injuries.
Yes.
So you're aware that he lost an eye,
Yes,
his skull was crushed in,
yes,
and that he was shot at more than once.
not by my son. Not to, I'm sorry. It doesn't matter. Yes, I am. And it's a terrible thing. And I'm glad that he is alive.
You're also aware he was stabbed. Is that correct?
No. No, I wasn't aware of that part, but I mean, it doesn't make it any better or worse. It's all bad.
You realize also that he was hogtied with his arms
Yes.
and his behind him
Yes.
and put it in his own trunk of his own car
Hmm.
and driven around and then dumped on the side of the road without many articles of his clothing, pretty much naked. Are you aware of that?
Yes.
Your son told you this?
No.
Okay, no further questions, John.
All right, any further questions? All right, you can call your next witness. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Uriah David Huffman.
All right, make sure you keep your voice up.
Yes, ma'am.
All right, defense.
Thank you, Your Honor.
All right, Uriah, you had a chance to go over this PSI. I'll just start there. Right.
All right, you're gonna have to answer yes or no.
Yes, sir.
Okay. And I believe you said there's a couple things you wanted to comment.
Yes, sir.
Okay. So let's just cut right to the chase about what happened to Joshua. You know, he's here to go. Right.
Yes, sir.
The PSI talks about you actually tying him up. Did you tell the probation officer you actually tied him up?
The probation officer?
That interviewed you for this. Did you tell them that you tied him up?
I don't believe so.
Okay. So as far as the tying up is concerned, because he was tied up, right?
Yes, sir.
Okay, how did you participate? What was your active role?
I just got the rope.
Okay.
And I handed it to DK, or to Daryl, sorry.
I'm sorry, could you speak up?
I got the rope and I handed it to Daryl.
Okay.
And that's your co-defendant in this case, who I believe you referred to as DK.
Yes, sir.
The PSI also talks about you putting Josh in the trunk of his
Yeah.
car.
Yes, sir.
Did you do that?
No, sir.
Did you tell probation you did that?
No, sir.
Did you drive his car away with him in it?
Yes, sir.
The PSI also talks about when you guys went and stopped somewhere in Atkins, and it makes it sound like you took part in the shooting. Like that you actively shot Joshua. Did you tell probation that?
No, sir. I mean, I told them that I was there, yes, but I never touched the gun. I never did anything like that.
Did you assist in removing Joshua from his trunk so that he could be shot?
I don't believe so, no.
Did you have a gun?
No, sir.
So are you the one that shot Joshua?
No, sir.
Who did shoot Joshua?
Daryl shot Joshua.
Now, you're not saying that you didn't participate in what happened to Joshua, are you?
No, I'm not saying that.
And I believe what's actually in the stipulated evidence is earlier that day, Joshua had actually hit you in the face with a guitar. Is that right?
Yes, sir.
And so you made DK aware of this?
And whenever DK pulled up to the trailer, he asked me why I was bleeding, and I told him that Joshua hit me with a guitar.
Okay. Did you ask DK to do anything to Joshua?
No, sir. He walked in and started doing that on his own.
Okay. But once DK started doing things to Joshua, you made a choice, right?
Yes, sir.
You chose to go get the rope.
Yes, sir.
You chose to drive the car.
Yes, sir.
And you chose to plead guilty as opposed to no contest, right?
Yes, sir.
So probably the biggest question in the back of the judge's mind is, based on everything that happened to Joshua, okay, and what you did participate in,
Yes, sir.
why in the world should she give you probation and not just send you to prison?
Because I understand that it was wrong in not calling the cops and participating in any of it. And I believe that I can prove that that's not who I am. and that I'll be able to complete probation and pay back any kind of restitution that goes to them, to Joshua.
Are you sorry for?
Yes, of course.
happened?
I'm sorry that all of it happened to him. He didn't deserve it, and I'm sorry to his family.
Well, they're right there, so you think maybe you should tell him and not us?
Of course, I'm very sorry that all of it happened to Joshua. If I could go back, I would have called the cops. I would have tried my best to convince DK not to do it. I'm very sorry.
You had an evaluation about your drug usage.
Yes, sir.
And I think it says in there you were using meth daily. Is that accurate?
Yes, sir.
Okay. DK wasn't just your friend, right?
What do you mean?
DK was selling meth.
Yes, sir. He was, yeah.
Okay. And all the people you were associating with at the time, including Josh, you guys were all meth users, is that right?
Yes, sir.
Again, if the judge takes a chance on you. That's a hard thing to shake. It was recommended that if you're granted probation, that you do inpatient therapy.
Yes, sir.
Excuse me, rehab. Are you willing to do that and do what it takes?
Yes, sir.
No matter, because there's several programs a judge could choose from, some of which could take up to a year before you're ever released.
Mhm.
Are you willing to do that?
Yes, sir.
Are you asking the judge for a second chance despite your choices?
Yes, sir.
Tell her that, not me.
Yes, ma'am. I would. I hope that you'll give me the chance and opportunity to prove that, or to give me a probation and even the drug rehab program.
I'll pass my Mr.
State.
Yes, Your Honor. Mr. Huffman, you said you didn't actually actively shoot. Mr. Pennell, right?
Yes, sir.
And you actively, I guess, grabbed a rope, handed it over to DK, which is Daryl King, right?
Yes, sir.
Daryl King's the one that shot Josh, is that right?
Yes, sir.
Who stabbed him?
I'm not aware.
You're not aware? You didn't have a knife?
No, sir.
You didn't have a knife.
No, sir.
And so the stab wounds, you don't know how that happened?
I'm aware that he got stabbed, but I don't
Who
know. how.
stabbed him?
All right, I'm gonna need you to speak up.
I'm aware that he got stabbed, but I'm not aware of who stabbed him.
Was there anybody else?
Was there anybody else that could have stabbed him?
Mhm.
Yes.
Who?
I don't know his name. It was just a guy.
So you don't have the guy's name.
No, sir.
So this random guy that you don't know his name stabbed Josh. Is that what you're saying?
No.
So who
I'm
stabbed him?
saying that there was another guy that could have done it.
Could have done it. So you could have done it.
No, that's not what I'm saying. You asked me if there was anybody else.
Okay.
Yes, there was.
You were there.
Yes, sir.
You were there when he got put in the trunk.
Yes, sir.
You were there when he got tied up.
Yes, sir.
You're the one that drove the vehicle around, right? In a hot trunk. And you knew that this individual had been stabbed, beaten, and tied up.
No, at the time, I did not know.
You didn't know he
found
had
out-
been beaten?
No, that he'd been stabbed. I didn't find that out until I was already in jail.
Oh, so you didn't witness any stab wounds. You didn't see him bleeding before he got shot?
No, sir.
He wasn't bleeding before y'all shot him on the side of the road.
I didn't shoot him. but-
I know, I said y'all, law parties in the state of Texas, if you're standing there, you're participating, and that doesn't mean you pulled the trigger, but you were there, right?
Yes.
And
Yes,
you
sir.
left with DK, right?
Yes, sir.
Was he bleeding before you shot, before you all shot him? Let's just say DK, I'm not gonna split peas with you. DK shoots him, you're standing next to DK. Was he bleeding before he was shot?
Yes,
Why was he bleeding?
because I assume he would, I can't tell you why he was bleeding. I'm sure
can't?
he got stabbed, but I don't know who stabbed him.
Did you hit him?
No,
You never hit Josh,
no, sir.
ever.
No, sir.
So DK did everything.
Yes, sir.
So DK stabbed him.
Okay, well, I don't know. I can't say for sure if TK stabbed him.
Okay. So he was bleeding before he was shot, right?
Yes, I mean, I
Hey,
believe I saw.
You were sober, you weren't doing drugs, you weren't drinking. Right? That's what you told everybody in this packet. You weren't drinking and you weren't on meth the day this happened. You said it twice. So you were sober when this happened, right?
That is what that says, but I've already tried to tell my lawyer that I was using at that time.
At that time, were you using that day or not?
Yes,
So now that's something else that needs to be changed in this package.
I thought that's what he said. I'm trying to.
I
make
don't
it
know,
clear
I'm
to
asking
him.
you.
Yes, that I was using drugs that day.
So these two items that say right here, it says defendant denied consuming alcohol and using drugs on the date of the instant offense. That means that offense that happened that we were just talking about. That's wrong.
I mean, yes, I did use drugs that day.
Okay. Before or after you all shot him?
So,
Sorry, I
Both?
can't hear you, sir.
both.
So you're using drugs before and after Josh was shot,
I had used drugs before. Yes, and
that day.
yes, that day. Yes, sir.
And then also right here, it says right here, I wasn't consuming alcohol or using drugs.
Yes, that's well, my attorney went through with me and I told him that was wrong.
Okay, so now that part is wrong also. That you
Yes.
were using alcohol and drugs.
Not alcohol, but drugs. Yes.
Okay, all right. So you deny, well, okay, you do remember him being tied up, right? What you call hog-tied, right?
Yes, sir.
And he didn't have his clothes on, right?
Yes, sir.
Why didn't he have his clothes on?
Because they got taken off.
Who took them off?
DK.
And you just stood there?
Yes, sir.
Was he hog-tied at the time that the clothes were being taken off or not?
Yes, I believe so.
He was. And then when was he shot?
He was shot behind the car.
Behind the car, when he was on the ground,
Yes, sir.
bleeding, already been cut,
It was
already
dark.
been stabbed.
Yes.
Tell me this. What do you think had happened to him after he got shot?
He laid on the side of the road.
Well, did you think he died?
Yes, sir.
Okay, so this is one step away from a murder, isn't it?
Yes, sir.
So why do you deserve deferred adjudication on this case? Tell the court that. Why do you deserve it? Because you almost committed murder. You see the man right there with his face bashed in and he has his left eye's not there anymore? Why do you deserve deferred for that?
Can't honestly say that I don't.
Thank
Or
you.
that I do.
Thank you. No further questions.
Defense, any other questions?
And I apologize, right? I did forget to ask you, we discussed it before, so. Did you want to clarify with the court, you were using drugs that day, right?
Yes.
But you weren't drinking?
No, I was not drinking.
Um. You knew what was going on, Joshua. Right? As the events are unfolding, you know what's going on.
Yes, sir.
You could have done something, right?
Yes, sir.
Why didn't you?
I wasn't in the right state of mind. I just been hit with a guitar. So I wasn't thinking clearly. DK, he told me to get the rope. He told me to do this and I chose to listen to him. Whenever I should have told him that, no.
What gave DK so much power over you that you
It's not that he had.
listened to him?
It's not that he had power, it's just that. I don't know, he's a very intimidating person and,
Is DK a little man or a big man?
you know, he's a big dude.
Did you ever know DK to be violent?
He always got what he wanted, yes.
DK was the one holding the gun?
Yes, sir.
Yeah, we need to make it clear that you understand. Okay. Even though you're saying you're not the one that shot Joshua. You're unclear who stabbed him. You helped, and the law says you're just as guilty.
Yes, sir.
You get that?
Yes, sir.
Despite that, are you asking the court for a chance to prove that you can change and you can be a productive member of society?
Yes, sir.
Thank you. Councilman.
No question.
All right, any other witnesses?
No, ma'am.
Any other witnesses from the state?
Nothing to say, Your Honor.
All right, with regards to the restitution amount, is there agreed upon restitution or no?
No, Judge. And if I can address that, we've been provided nothing as far as what these amounts come from. And so I believe, despite if there's proof that we provided, he owes it, he owes it. I mean, that's, but I think we need to have a restitution hearing on that. When it comes to the victim in the instant case. Mr. Lavario, who is the complainant in the UMV case that's being TIC'd. Again, it's a very big number he's alleging with no proof. I will also point out that in the discovery given to us by the state, Uriah is found in this gentleman's stolen pickup, and there are no tools there. He's not found with them or anything. There's also some conflicting statements that he gave, so I would require a restitution hearing on that one as well. But again, whatever he owes, that proofs provided he owes.
All right, this is what the court will do. The court is going to deny your application, find you guilty, sentence you to 12 years in the prison, give you credit for any time served. There's a $5,000 fine, time and money will run concurrent. Take in consideration 2022 CR 7208, 2022 CR 7210. I can order the therapeutic community. It'll be up to them whether or not they place you in the therapeutic community. I absolutely have no jurisdiction over that. So if you would like, I could put that in the order.
Yes, ma'am.
There's an affirmative finding of deadly weapon. There's to be restitution, if any, and no contact with Joshua Sandoval and Ramon Lavario. Going to show you what's inside titled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know that 12 years is a lot of time. Honestly, anytime you do, whether it's at the Bexar County Jail or wherever it's at the prison, that's a lot of time. But I did internalize everything that was said. I listened to all of the witnesses. If you have a drug or alcohol problem, you need to use this time away to get your life in order, to concentrate on what improvements you want to make so you don't be back here. The complainant in this case has permanent injuries, and those injuries will never go away. You can go to jail, do your time, get your life in order. You can even get a college degree at the jail. And I could be wrong, but I don't even think they have to pay for the degree. So you can get a free degree at the jail and work on yourself, figure out how you got in this situation and not put yourself in this situation again. Do you understand?
Yes, ma'am.
All right. Is there a victim impact?
No, Your Honor.
All right. Good luck to you.
Thank you, ma'am.
Thank you, Judge. Maybe excuse.
Yes. No, we'll be back at 1:45.